Good evening. Welcome to this is actually our round two of having a guest speaker here of our new learning session with A&A CPA LLC, our Ask an Accountant Zoominar on Wednesday nights. Thank you all for being here. And we have the amazing Thomas McGuire. I'd call him Tom because he's a great guy. We met him with a mutual client recently, and he just is a wealth of information with some legal things we were looking at, doing a lot of estate planning, and it's something that Tom is going to talk about estate planning tonight, answer your questions, may answer some other questions that you have. Put those in the chat at the end of his presentation. We will probably open up the, um, make it so you guys can unmute and raise your hands, but everybody's muted right now. So Tom, take it away. Thank you for being here.
Great. Thank you, Bill. Thanks for having me. And Judy, thank you for setting this up. Good evening, everyone. As Bill just said, my name is Tom McGuire, and I do go by Tom most of the time. I am a trust and estates attorney. My firm is called Saul Ewing. We're a Philadelphia-based firm, but I'm in a Chicago office. And this is what I do, estate planning. That's most of my practice. So I was asked to speak tonight just about some estate planning basics, things you need to do to protect your assets and to protect your family. And so I do have a presentation to share. I'm calling this presentation Planning for the Future, the importance of estate planning to protect your estate and loved ones. So first of all, this is me. I'm sure Bill and Judy can share my information. That's my firm. All right, so estate planning.
That's actually not his photo. That's somebody else.
That's not me, and I don't have a baby.
I had to be a smart aleck.
All right, I don't have a baby. And by the way, the photos I have used are permissible photos that came with PowerPoint. So they're not, there's no copyright infringement here on these photos, just so you know. So what is estate planning? Estate planning is a pretty broad concept. I mean, it's not only planning for where your assets pass at your death, but also for your protection if you become incapacitated, for providing for your family in the way of guardianship for children, and things like that. So there are a number of documents which I consider to be essential documents for an effective estate plan. And I'm going to walk through these one by one, but this is the initial list. A will, a healthcare power of attorney, a property power of attorney, which you may sometimes hear of a durable power of attorney. That's the same thing. A living will declaration, and then a living trust or a revocable trust. Interchangeable terminology, they're the same thing. And then I will talk about, do you always need a living trust? There are some situations where maybe you do not need a living trust, but in most cases, I would probably recommend a living trust. All right, so let's start with the will. So what is a will? A will is a document that provides for what happens to your assets when you pass away. If you create a living trust, the will's pretty simple. It's what's called a pour-over will, and it's called that because it's like all the will says is anything that you didn't put in the trust while you're alive, which we'll talk about in a minute, gets added to the trust. So in other words, it pours over like a pitcher pouring into a glass. That's why the term pour over will is used. If you don't have a trust, you would basically incorporate provisions that might otherwise be in the trust in the will. So for example, if you want trust provisions for any family members, such as children, you can do that in the will itself. Then that's called a testamentary trust rather than a living trust. And the big difference between the two is if you just have a testamentary trust in a will, you will likely be going through a process of what's called probate. Probate is a court process where the will gets filed, a judge approves it, appoints an executor that you name in the will, and it's under court supervision. It has to stay open for a certain period of time. In Illinois, that's 6 months. 6 months is a period of time creditors can come in and file claims against the estate. It's also the period of time that someone can come in and contest the will if they believe that the person was of unsound mind or unduly influenced to create the will. So the will does create, it names an executor. So you got to keep track of the terminology here. An executor is a person who's named in a will to administer an estate, as opposed to a trustee in a trust. Often those are the same people, but the terminology is a little bit different. The will is very important for anyone who has minor children, because that's where you name guardians for your minor children. And again, you should distinguish between guardians and trustees. So guardians are the people who will have physical custody of children, will raise children, and make day-to-day child rearing decisions. The trustee will be the person who will manage the assets for the child, make investment decisions, and then ultimately distribute the assets to the child once he or she reaches a more mature age, as you would specify. The guardian and the trustee can be the same, but they don't necessarily have to be the same. Obviously, it's convenient if the guardian and the trustee are the same. The guardian knows what they need. They're in control of the money, so they can just make distributions as needed. Some people, on the other hand, like to have some checks and balances. They want the guardian to be accountable for the funds they're using to the trustee. And then a third factor that comes into play is sometimes the person you absolutely have no problem with raising your children, you think they'd be great parents, are not the people you're most comfortable with managing money. So all those factors come into play when you decide between guardians and trustees. I'm going to do some of these other more minor documents before I get to the trust, which is the kind of the meat of the discussion here. Healthcare powers of attorney, they kind of are self-explanatory. So these are documents where if you are living but mentally incapacitated, you name an agent who can make healthcare decisions on your behalf. Usually it's a good idea to name a first choice and a backup in case the first choice is unable to act. People think of a healthcare power of attorney as, pull the plug, life and death decisions, which is true. It may be applicable in those situations, but it's actually much broader than that. So if you're just, you're in a car accident and you're unconscious and someone needs to consent to a surgery, your agent under your power of attorney would be able to do that. You can include specific wishes on certain subjects in your healthcare power of attorney. For example, you want to be buried versus cremated, if you want to donate organs or donate your entire body to science, if your agent can authorize an autopsy. There's a couple other things in there that you can include if you wish. But this is a really important document that everyone should have regardless of their situation. I should point out that there is a statute in Illinois called the Illinois Healthcare Surrogate Act, which does say that it gives a priority to certain people to make life and death type medical decisions, even if you don't have a healthcare power of attorney. But it is pretty limited to extreme situations, and it's pretty logical about what the order of priority is: your spouse, then your children, and then if it's more than one child, there's no real clear guidance there. So it's probably better, even though that statute's out there, to actually go through the process of putting together that healthcare power of attorney. The next is the property power of attorney or durable power of attorney. And again, this is only relevant while you're incapacitated. Once you die, a power of attorney terminates. So the exception to that is in a healthcare power of attorney, if you give direction as to organ donation or donating your body, that obviously survives your death. Otherwise, it wouldn't really mean anything if it terminated at your death. But in a durable power of attorney, think of that as anything other than healthcare. So that's really, you're giving an agent the power to manage your assets, pay bills, do all the things that you could do if you weren't mentally incapacitated. When we talk about a trust in a minute, if assets are in a trust already, the trustee that you name would step in to manage those assets. But a durable power of attorney usually supplements even a trust, because there are sometimes certain assets that will not be in the name of the trust. The biggest example is retirement accounts. So while you're alive, your retirement account, IRAs, 401ks, 403bs, whatever they may be, they need to be in your name. And even if you were to name a trust as beneficiary on those types of accounts, the beneficiary is not relevant until your death. So while you're alive, there needs to be somebody who can actually manage those accounts, direct how how they're to be invested, when distributions are made from IRAs and that sort of thing. So the durable power of attorney supplements the trust. And oftentimes the person that you name as agent in the durable power of attorney is the same person you name as trustee, because frankly, they're both asset management related roles. But that is an important document. Next is the living will declaration. Living will, basically, this is a pull the plug document. If you're terminal and incurable and would not be able to survive in the absence of life-sustaining treatment, you're directing your physician to pull the plug. If you have both the healthcare power of attorney and a living will declaration, the healthcare power of attorney is always going to be controlling. So the living will it expresses your wishes, but if you have an agent under a healthcare power of attorney, ultimately that agent is going to make that decision regardless. If you don't have a healthcare power of attorney, the living will declaration allows your doctor directly to make the decision to terminate the life support without having any liability for doing that. And here you can add provisions about, medication, pain medication. You'd want to continue that even if you don't otherwise want to be on life support. Whether or not you want to have feeding tubes, nutrition and hydration. If those are the only things keeping you alive, whether you want to have CPR. There's different things that can be built into the living will declaration. All right, so then the main topic of discussion here is going to be the revocable living trust. A living trust basically is a will substitute, but it's more than that. So I say it's a will substitute in the sense that it does, if you have a living trust, it will specify what happens to your assets when you pass away. It'll substitute the provisions you would substitute for the provisions you would have in a typical will. But it's more than that in that it also covers incapacity. So if you have assets in the name of the trust and you become mentally incapacitated, the trustee that you've named in the trust has the ability to step in and manage the assets without a guardianship proceeding. Typically on these living trusts, you would start as your own trustee. You'd be able to manage things as long as you can. You have full control over the assets. You can amend or revoke the trust at any time. But then when something happens to you in the terms of either death or incapacity, or if at some point, someone's older, they might just want to resign as trustee and let, that one of their children step in, that happens as well. So as far as by having assets in a living trust, you can avoid probate and you can also avoid guardianship in the event of incapacity. This is really important though. People think I have a living trust, I'm not going to go through probate. Well, actually people sometimes say I have a will, so I don't have to go through probate, which is also not true. A will does go through probate unless you have assets in a living trust. So if you set up the living trust, it's important to do what's called the funding of the trust. So funding is titling your assets in the name of the trust, naming the trust as beneficiary on life insurance, retirement plans, things like that. Although retirement plans are a little trickier because there's income tax consequences. So sometimes you do want to name a trust, sometimes you don't. But the whole idea is if you don't put the assets in the trust, you're not going to avoid probate. The assets may end up in the trust through that pour over will, which is more like a safeguard to make sure things end up in the trust. But just by signing a living trust and doing nothing further, you're not going to achieve your objective of probate avoidance. And it's a big misconception of people that they have a living trust, I don't have to go through probate, yet they've done nothing to actually title their assets in the trust. So that's really, really important. Trusts are also very useful to minimize estate taxes. And estate tax is a one-time tax. It's a death tax that you pay based on what you own at the value of what you own at the time of your death. There are exemptions from estate tax. At the federal level, the exemption is very high right now. It's $12.92 million per person. So between a couple, that's almost $26 million if my math is right. That exemption is going to be cut in half after 2025. So you'll be working with half as much exemption. It is inflation adjusted every year. So it will be going up. Even after it gets cut in half, it'll be going up, but the exemption is going to be reduced. The federal exemption is also portable, the term portable, Portable. And what that means is for a husband and wife, when one spouse dies, if they haven't fully used up their exemption in their own estate, their assets were less than the exemption, any excess would carry over to the surviving spouse. So that's really a nice thing that between the spouses, so basically between the spouses, you get the whole amount, regardless if one person dies first and doesn't have anything in their name, and there's a lot more in the second name. So a lot of people, this is a pretty high level for an exemption right now. For many, many years, it was only $600,000 per person. So the planning was, there was a lot more estate tax planning than there is now. In Illinois, planning is still very important because the Illinois exemption is only $4 million. And it's not, it is 8 million per couple, but it really isn't. And what I mean by that is the Illinois exemption is not portable. So if one spouse dies and they don't have the full 4 million, let's say one spouse dies and has $1 million in their name, and the surviving spouse has $6 million. At the first death, you've only used $1 million of exemption from that spouse. At the second death, you've used 4 million, so you have 2 million taxable. Whereas if that was federal, you would have had no tax because of the portability. So for planning for the Illinois exemption, it's really important to make sure that the assets are somewhat equalized between the two spouses, so that no matter who dies first, you're able to take advantage of both spouses' exemptions. So when you're deciding what you want to do in your estate plan, there are some important decisions you need to make. The biggest decision is, who do you want to leave your assets to? A lot of times it's, to your spouse first and then to your children. We can build in provisions to make sure that you're maximizing the estate tax exemption. There's things called marital trust, family trust that are built into the documents to make sure that you're minimize, basically, so you're avoiding any estate tax when the first spouse dies, no matter how much, and then you're minimizing the overall tax that's ultimately payable. When you're leaving property to children or other minor beneficiaries, or even adult beneficiaries, well, for minors definitely, and even for adult beneficiaries, you may want to leave the assets in a continuing trust where you name a trustee who can dole out funds as needed for health, education, support, things like that, but have the assets under the control of that trustee at least until the beneficiaries are older, or sometimes it may go through the beneficiary's entire lifetime. For example, if you have a special needs beneficiary. So it's really important to figure out if you are going to have distribution points for a trust for children, for example, when should that be? So a lot of times you'll see, 18 is legal age. I honestly don't agree that leaving a lump of money to an 18-year-old is a good idea. So a lot of times people will do stages of distribution. For example, it's pretty common to say, a third to my children at age 25, a third at 30, and a third at 35. It's kind of the more than one bite at the apple approach. So they get a third at 25, maybe they waste it, but there's still 2/3 of it held in trust under the management of the trustee. So the distinction is, if you specify ages of distribution, you're giving it to the beneficiary at that point to do whatever they want. If they waste it, they waste it. If they give it away, they give it away. The part that's still under management, the trustees in control and doling it out as needed, but there are strings attached. So once the trust is fully distributed, it's up to the beneficiary to live their own life and do what's best. You may want to include charitable beneficiaries in there. You may want to include specific bequests to people. If you are in an estate tax situation where you're over the exemption, charities are exempt from estate tax. So every dollar that you leave to a charity in your estate plan reduces your taxable estate for estate tax purposes. Sometimes people will include charities as like contingent beneficiaries, like if everybody's gone. And if you have a small group of beneficiaries, let's say you're a couple with one a young child. Let's say you're a young couple with one child. It's really important to think about your contingent beneficiaries because you're together all the time. You may be traveling. There may be an accident. Something could happen, and then who would you want to inherit if everybody is deceased? And there you may be dividing it somehow among family members, charities. You can do dollar amounts to certain people, percentages to others. So there's a lot that you can do there, but you really got to think through, what you want to happen in this contingent situation. And with that said, everything I'm talking about right now is revocable and amendable. So you can change things in the future. However, I always think it's a good idea to build at least some contingencies in the document so that you don't have to amend every 5 minutes or whatever, because things happen, things change. It is important to review your documents from time to time, which I'll get to in a minute. The other most important decisions are the people involved, as far as who's going to be your executor, who's going to be your trustee, who's going to be your healthcare agent, and who's going to be your property agent. A lot of times you'll see people name the same person as executor, trustee, and property agent. Obviously, healthcare is a totally different type of decision. So often you may see a different person in that role, but it might also be who you named in all those other capacities. And here it's a good idea to name first choice and second choice. I always like to have at least one backup named in my documents, even though you can amend them in the future. And then guardians. Obviously, guardians are the most important decisions for anyone with young children. This is who you're entrusting your children to, who will raise your children. One thing I always want to clarify with people. They'll tell me, okay, I want to leave. If I want my brother and sister-in-law to be guardians for my children if both my wife and I are deceased. I said, okay, what are you really saying there? Do you want your brother? And if the sister-in-law is in the picture, she's involved. But what would happen if the brother died? Would you still want the sister-in-law? Is it only if they're married at the time? What if they get divorced? I mean, you got to think through these options as to what you really mean when you think about who should be your guardians. All right, what else we got here? So once you set up, these documents, like I said, the funding of the living trust is really important. I know Judy said, A&A can probably assist you with this process for at least some of it. It's important not only to equalize the assets for state tax minimization, particularly Illinois state tax, but also to achieve your objective of avoiding probate when you pass away. I do recommend, when I prepare documents, I keep track of those documents. So if there are changes in the law that affect you, I would tell you. The exemption in the trust is a floating exemption. So even though we have that $12.92 million exemption, you'll never see that in the document. It talks about whatever the exemption is. So that's floating. So that adjustment is built in automatically. But if there's any other like major changes in the law that would require you to change your documents, certainly, I would let you know. But it's important that you pull out those documents I'd say at least every 5 years, maybe more frequently, and just look at them. It doesn't mean you need to contact your attorney at that point, but just pull them out, say, okay, is this still who I want as guardian? Is this still who I want as trustee? Has anything changed as far as my children are concerned? Now, I've been doing this for quite a while, and it's pretty funny. The one thing that I see getting changed is the ages of distribution to children. So you start out when you have, little kids, say, oh, I'll give it to them at 25. And then as they're getting in their teenage years, like, oh no, we're pushing this back. We got to do this in stages. So you'll see, things are changing in your life. So it's important to monitor your documents to see if anything should be changed. And the nice thing about these documents is once you set them up, it's usually just a question of amending them in the future. It's not reinventing the wheel. So for example, in a trust, you just do a trust amendment. For a will, you just do a codicil to the will, which is a legal term for an amendment to the will. So it may be just a 1-page or 2-page amendment or codicil. You're not starting from scratch on all that. All right, I'm not going to get into this other stuff, but I just want to mention there are some advanced planning techniques. For example, if you're over the estate tax exemption and you have a lot of life insurance, there are what are called irrevocable insurance trusts. Irrevocable insurance trusts are a way to get the insurance out of your estate on top of using the exemptions. So it actually can be a really useful technique if you have a large estate with a lot of life insurance. There's what's called GST or generation skipping tax planning. So that involves leaving assets to your children or the next generation in a continuing trust that goes through their entire lifetime. This term is kind of misleading because you're not skipping. You're skipping in the sense that you can set it up in trust for your children where it's available as they need it. At some point, you can have them be their own trustee if you want, but it's structured in a way that it never just distributes outright to them. And that has some advantages in that it keeps the assets out of their own estate when they pass away, if they should have a large estate that would otherwise be subject to estate tax. It also protects from creditors, and it also can protect from a spouse in a divorce situation, a child spouse. So I'm seeing more and more of that type of planning. Gifting, there's all kinds of means of gifting. When you have a large estate, often you want to gift to reduce that estate. You have annual exclusion gifting, which is your free gifting. That's right now it's $17,000 per person to as many people as you want. You don't have to file a gift tax return. You can be doing direct gifts. You can be putting into 529 plans or education plans for grandchildren. UTMA accounts, that's a custodial account. You'll hear that term. And there are other acronyms. There's what are called SLATs, QPERTs, IDGITs. These are all really advanced planning, but they all build on your basic plan, which is the other documents that I just spoke about. So it's really important to get your basic estate plan in order first, and then look at the size of your estate and the composition of your assets and see if any advanced planning may make sense. The thing about advanced planning is most of that is irrevocable planning. So everything I talked about, you can change at any time. A lot of the advanced planning, although there's ways to build in some flexibility, like using what's called a trust protector, powers of appointment, things like that, in some sense, it's irrevocable. So it's a little more difficult to change in the future if you want to change it. And I think that's about all I wanted to cover today. So, I can open it up to questions, or Bill and Lorna and Judy, however you want me to handle this.
Well, I think questions is good. I know that Mark could ask one. I'll ask Mark to unmute, and he can ask his question.
Yes,
we're talking about funding. Go ahead, Mark.
Yeah, I was just asking about funding a trust. Is that like funding it with a checking account or putting your house in a trust? Is that what's considered funding a trust?
Yeah, funding, it depends on the nature of the asset. So for real estate, it would be a deed to put the house into trust. You would deed it into trust. So rather than, an asset being the name of Mark Smolensky, it would be in the name of the Mark Smolensky Trust. You'd be the trustee. By the way, these trusts that I'm talking about, these living trusts, they're ignored for income tax purposes while you're alive. So they don't have any separate tax reporting. They don't have a separate tax ID number or anything like that. Once you pass away, the trust needs to get a new tax ID number. But it's important to know that it's ignored for tax purposes when you're talking about real estate, because by putting in the trust, you don't interfere with your homeowner's exemption, senior exemption, your right to exclude capital gain on the sale of your residence, things like that. All that still applies. When you're talking about other assets like regular investment accounts, bank accounts, things like that, it would be a question of changing the account title to the name of the trust. So while you're live, it'll be Mark Smolenski as trustee of the Mark Smolenski Trust, dated whatever. Trusts are usually identified by your name and a date. That's typically how you identify people. Some people want to make up a separate name for it, which you can do, but in most cases, you just name it after yourself, and the date of it, which is important for identification purposes, would be the date that you sign it. Some things like retirement plans, there's income tax considerations, as I mentioned earlier. So it may be beneficial, particularly if you have adult beneficiaries, to name them directly rather than naming the trust. The reason being, it used to be if you named an individual beneficiary directly, they could do an inherited IRA and stretch out over their life expectancy, stretch out the payments. That changed a couple years back, and now it can only be stretched out for no more than 10 years. But if you're payable to the trust, depending on the terms of the trust, it might only be 5 years. So it does shorten the payout to some extent. So we'd want to look at that. And there are things you can build into the trust to allow it to be stretched out further. But yeah, you just want to look at all your types of assets, and things like LLCs, you would just put your membership interest in. Corporate stock, you would put membership interest or your stock in the name of the trust. The idea is to have as much as possible in the name of the trust. All right,
Thanks for the question. And Islam had a question, and you can unmute yourself if you want to ask, or I can read it.
Yeah.
So go ahead. What was your
Yeah, thank you,
question?
Bill. Yeah, thank you, Bill. So just to add to Mark's question on basically what does funding mean? So I mean, examples. I mean, what about stocks? I mean, just stocks that you have in the public markets. What about investments in private companies? And what about carried interest that one would get, as a GP?
Okay, so the public company, that's an easy one. If you have an actual stock certificate, you'd want to retitle it. I mean, most everything would be in book entry form these days. So you would just title your brokerage account or wherever it may be, or your direct registration account in the name of your trust. For privately held companies, it's part of that's going to depend on if there are restrictions on transfer for the stock. A lot of times there may be transfer restriction, and then for an LLC, things like that too. There may be transfer restrictions, but there may be what's called permitted transferees. And oftentimes a revocable trust like this is a permitted transferee. So you'd have to see what the rules are. Carried interest is a little more complicated because you don't want to trigger any recognition of the triggered interest. So sometimes on that, you may need to name a beneficiary rather than actually retitling your carried interest in, because that's the other option for a lot of these assets. You could just name the trust as beneficiary at your death. So your bank account, you could say, on my death, it goes to my trust. And that works. It just, the reason I think it's better to try to get the account itself in the name of the trust is it covers, because then you're covered for both disability and death. Whereas if you just name trust as beneficiary on an asset, that's not effective until your death. So then you'd still have to deal with a disability situation. You could handle an asset if you're disabled with the power of attorney, but it adds some complexity to how you would deal with the asset. Whereas if it's already in the trust, your trustee steps in and can manage it.
Thank you.
As usual, Tom, it occurs that when you're talking about this planning, it sounds like there's some basic, simple things of like, do this and we'll keep it out of probate. But if you don't dot the I's and cross the T, it's like going online and creating your own corporation.
Right.
That corporate veil gets pierced right away the next day in court when you didn't keep your shareholder minutes, for example. So
Right.
it's something that there's making sure that you do complete work. One thing you mentioned that I was curious about, we're going to take the exemption in 2025, and you said it was scheduled, quote unquote, to be cut in half, which means that they can always change their mind on what they're going to do. What about
Bill,
Illinois? Is it
I
going to
don't
be
think
cut in half?
Congress can do anything right now. I don't think they're going to change their mind.
That's true. They're not doing
big,
anything.
right?
But will
So
Illinois be cut in half or just federal?
that's just federal. They're totally
Okay.
separate. But Illinois does not. Illinois does not have an inflation adjustment, so that's important to know. And there is absolutely no discussion of increasing that exemption anytime soon. So
And when you talk about equalizing the estate, one big difference in the estate could be having two different 401k accounts, for example. That's not something that you can easily equalize those outside of getting a divorce that I know of.
true. So a lot of times what I will do is I'll look at what those types of assets first, and also life insurance.
Yep.
And then kind of build from there and say, okay, you already have this on your side of the equation. You know, should we, maybe put more in, the wife's trust or something like that. And sometimes we're also going to look at creditor risk issues. So for a doctor, for example, a lot of times they may put more in the non-doctor spouse's trust to give it protection. Living trusts themselves will not protect you from your creditors. That's important to know. People think living trusts can protect them from creditors. They can protect your beneficiaries from creditors. So typically in a husband and wife situation, you'll set it up. Husband sets up a trust that says, when I die, everything's in trust for my wife for her life. She can be the trustee. She can use it as she needs it. But then when she dies, it goes on to the children. That is protected, the wife's interest in that trust, if it's structured that way. Likewise, if you keep a child share in a continuing trust, it's protected. And when you're talking about funding of the trust, if you take assets that were joint or in one spouse's name and put them in the other spouse's name, it will be protected from the creditors of the spouse who are no longer owning those. If it's a joint creditor, there's still some risk. And obviously, in that doctor scenario, I just thought if you put everything in the non-doctor's trust, but then that doctor or that person got sued for something, it puts those assets at risk. But you got to kind of measure your risks. You always got to make sure you have probably an umbrella policy on your insurance. I mean, there's always first lines of defense when you're talking about creditor protection.
Awesome.
Maybe simple question, if I may ask, just
Sure.
to make sure, I think
Sure.
it was covered. So real estate, if you retitle it to the trust and there is a mortgage on it, the mortgage does not need to be refinanced, right? Because
That's a very good question. That's an excellent question. So if the property is your personal residence, you can transfer title to your trust without even notifying the lender. The lender can't do anything about it. There's a federal statute that says it does not trigger like a due on sale clause on a mortgage. So it doesn't accelerate the mortgage. So you can do it for your personal residence. If you're talking about putting some other property that's not a residence and has a mortgage on it in trust, generally you would need to get lender consent, which in this market right now might be a little more difficult. For a long time, lenders could care less because the interest rates were so low. But now conceivably they could say, well, you had this really good rate and now you transferred it. We might want to have you refinance that at a higher rate. So yeah, for anything like that, you would need to get lender consent without potentially causing an acceleration. But for any personal residence, that does not apply.
Thank you.
But on the investment property, Tom, that's only going to apply if you bought it in your name.
Yeah.
So
it's
if
an
I bought it
LLC
to
or
an
something.
LLC, then it doesn't matter because I'm not transferring the real estate, I'm transferring the LLC to my trust.
Right. So that in that situation, the property would still be it would be titled in the LLC and you would just assign your membership interest into your trust, which lender doesn't even know about that. It's not of record anywhere.
Yeah. it won't have any impact on that.
Right, right.
Yeah. And then Dr. Nam had a question, naming as beneficiary versus changing to the trust. I don't understand your question, Dr. Nam.
I think I understand. It's like,
Okay.
some people say, well, I'll just name the trust as beneficiary of my assets. I want to keep the title the way it is. And like I said,
Oh, got it.
you can do that, but then you have the risk of an incapacity situation where then your agent under your power of attorney would need to be able to access that asset. But people are doing that. Some people, it's certainly easier. Like if you have an existing bank account or brokerage account, to name a beneficiary on it, all you got to do is fill out a form to name a beneficiary. Whereas if you move it into a trust, you usually have to get a new number, account number, and then it's like a transfer to a new account. So there is a little bit of paperwork up front, but
Got it.
so.
Then is it beneficial to change into on the trust name then, do you think? After
think for you,
because I
go ahead.
I definitely think my husband is the first beneficiary, and after my husband passing, I mean, just is like a divide by between my children, 2 of them. That's
Okay.
exactly same thing under the trust, or my will be same thing. In the case, it's the same thing, right?
Right. So
If
if your trust was just going to leave everything to your husband and then to your children outright,
Mm-hmm.
beneficiary designation accomplishes the same thing. You're
Yeah,
right.
yeah.
But if, for example, there was going to be any like continuing provision for like a child in trust, you may not want to have the child named directly as beneficiary. Maybe you want to name the trust instead.
Mm.
But if it's just like adult children,
Yeah.
you're not going to have any strings attached. You just want to do, certainly that's an easy way to do it. Yes.
Okay. Yeah, I just want to be clarified because everybody says fund the trust, but it's kind of a taking hassle. Okay, thank you.
You're welcome.
Tom, I have a question when it comes to irrevocable trust. I do loans with FHA, and it seems like when we do loans and they have to be reviewed, these trusts, when it comes to an irrevocable, we cringe because there's usually something in there that we can't do anything about. And if it's in the irrevocable trust, we can't change it. So what's the advantages of an irrevocable trust?
Well, first of all, let me address, so on irrevocable trust, you may be able to change it if they're like, for example, like a lot in more modern irrevocable trust, you can include a trust protector provision where you basically the person names like a independent third party, a friend or someone who has the ability to make changes in certain circumstances. So like if you needed to have certain language to qualify for the loan, that could potentially be done. But the purpose of irrevocable trust is usually to be getting assets out of your estate. So by either gifting or insurance trust, those types of trusts are usually assets where the assets in those trusts are no longer going to be counted when the person passes away in their estate. And typically when I see loans to irrevocable trusts, I see a lot of personal guarantees, which I'm sure you probably have to do sometimes on some of those.
Thank you.
Other questions, comments? We talked about the assets. Tom, would you, that slide that you put up in the beginning that had your information on it, put that up again and just let people take a picture of that if they want with their phones, or do a screenshot if they didn't get that, just in case they have other questions or something.
Sure.
I mean,
It looks like another question just came in about how
Okay.
long it takes to set up. So that depends on you. Typically, I would either meet with you, I'd have you fill out a questionnaire, give me some of the background, and then have a call or a meeting to kind of go over the details. once I know what I'm preparing, I've literally done estate plans in a couple days. Like if someone's going in for surgery or something, obviously that's not the ideal situation. Typically to draft documents usually takes me a week to 2 weeks. And then I send them out to you with basically a letter summarizing the documents. We can go back and forth with any changes. And then once you're ready to sign, the documents need to be witnessed and notarized. So either if we could meet to do that, all through COVID, I've been doing Zoom signings of documents, which are allowable. Basically, with a Zoom signing, you print everything out and sign on camera and then send them back to me. I would have a witness available on the call. I'm a notary, so that comes in handy. Or I can just give you instructions for what you need to do, but then you need to find witnesses in Notary Public, which people think is easy. But even with banks these days, you may be able to get a notary, but getting a regular witness often is not that easy to do. And then the funding process, that's kind of really at your own pace. Once the documents are in place, the pour over will's there just in case anyway, but it is important then to move forward. So we could get done within 2 to 3 weeks, I'd say. All right, let
Good.
me,
If I
Have
may
you
ask,
found, Tom, that takes the estate planning takes a bigger, I don't know, you talk about disability, and it seems like that's more of an important thing, because I can do all sorts of living trusts and everything, so when I croak, it all goes, right?
right,
But there's no plan for what happens if I don't die.
right.
So it seems like the incapacitated is a huge area where the planning would be very critical to me.
It is, I agree, I agree. I think someone just asked about if you moved from another state. So the wills and trusts, basically, those are good no matter where you live. Every state has a statute called the Uniform Recognition of Wills Act that says if the document was valid in the state where you signed it, it's valid. And that typically applies to the powers of attorney and living wills too. However, at least on the healthcare power of attorney, if you do relocate to another state, every state, well, not every state, but many states have their own form. Some states don't even have a form. They just have a statute that doesn't really say what you need to do. But like Illinois, when I prepare a power of attorney in Illinois, it says Illinois statutory short form power of attorney. So if you move to another state, you might want to redo your healthcare power of attorney in that state only because doctors and hospitals are familiar with that form. And, you don't want to have them having to spend time looking at some foreign document to them. Wait, what's this question? How to avoid amending a trust if it has a private company asset where your percent ownership may change? I
Tom,
don't
do you
know.
want me to explain this a little bit?
Oh,
You want me to explain this a little bit? So let's say that the trust does have an investment in a private company. You have, let's say, 10% share. For whatever reasons, next year it is 12%. So do you have to amend the trust? I mean, because actually the trust would say that you have a certain percentage or what?
No, it does. I mean, only if you like made a specific bequest of that stock, let's say, and you said, I give my 10% interest in this company to so-and-so. But if you just say, I give all of my interest in this company to so-and-so, even if it changes, you don't necessarily have to amend the trust. It's
Okay.
just when you acquire the new interest, if it's like a new issue of some type, you would have to title it in the trust. I mean, if it was just like a stock split or a
Yeah.
stock dividend, it
Yeah.
would seem like once you have the original shares in the trust, that would kind of automatically happen because it would go with the way that the title reads at that time. Does that make sense?
Yeah, I mean, I was talking about a case where there are, capital calls, right? And some people go, actually fund the next capital call and others do not. As a result, your percentage, if you fund, will increase. So it's not related to a distribution or a dividend or a split.
Yeah, so no, I mean, as long as your ownership interest is in your membership interest is in the name of the trust, even though it's fluctuating, like a partnership interest, if it's in the trust, your interest is in the trust. If it fluctuates, but the actual assets in the trust.
Sounds good.
All right, let me give you my
May I ask one question?
course.
And I know that's very variable, highly probably, but what's the cost of setting up for somebody who's not really complicated, like one retirement account, couple, savings or investment accounts, and one house? And then is there any continuous cost, like do we have to pay some fees every year to the government or?
So the first question is, yeah, cost does depend on how complicated things may get. When I'm doing what I would call a fairly routine estate plan for a married couple with children, where there are continuing trusts for the children built in, with all those other documents I talked about, cost usually comes in between $2,000 and $3,000. I think that's a good ballpark estimate.
Okay.
As far as maintenance, there's no filings or anything you have to do with the government. Like I said, if you ever want to amend anything, obviously there'd be a cost to prepare like an amendment, but you're not talking about nearly that much. It might be a couple $100 to do a one-page amendment. Once you pass away, the trust will get its own tax ID number, and then there will be income tax filings going forward for the trust, but that's not while you're alive. That's only after your death. So there would be that cost of preparing an income tax return for after you pass away.
Thank you.
You're welcome.
I want to add here, there's two additional costs. One, there's cost if you have somebody help you move all your assets. It depends on how many assets you have, but it's very important, as Tom was saying, once he does the documents, he's not there to make sure that everything gets retitled. So you may have to pay a professional fee to have your assets moved. And the second thing is I normally recommend to all my clients that at a minimum, you talk to your attorney every 3 years, just to give them an update on what's gone on in your life, so that if it's going to impact the documents that are there, he can do an amendment. So it's like not once and done, it's once and reviewed is what I normally recommend.
And that makes sense. And let me just back up 1 minute too. There will be, like, if there's any transfers of real estate into the trust, there would be recording fees there. They're usually not huge in the big picture. And I do give you instructions for titling assets and beneficiary designations. But like Judy said, I don't do all the paperwork to do that sort of thing. I can prepare deeds for you because those are legal documents. But for the other types of assets, I tell you what you should be doing. But someone like Judy or Bill, or they can help you with that sort of thing. Sometimes it's just dealing with your broker, your banker, whoever it may be.
Awesome, Tom. Yeah, there's always going to be the follow-up working with anything, whatever it is. You always want to make sure you're doing complete work and dotting the I's and crossing the T's. And I think that's probably important. So,
and on the funding point, one more thing. On the funding point, it's also important, when we do all the documents, people up front, they're usually pretty good about going through these steps that I said as far as retitling and beneficiary designations. But when you have a living trust, it's important to remember that. So in the future, you buy a new property, you acquire some new, you open a new investment account, whatever it may be. Always keep in mind you have a trust and title those assets, those new assets in the trust as well.
So if you have the living trust, do you go buy your cars in the living trust?
No, cars are usually an exception unless you have like a car collection.
Oh, that's a good point.
Typically, I would say don't title your cars in the trust because it's more trouble than it's worth. And one point I didn't mention is Illinois has what's called a small estate procedure. So if you were to die and you had less than $100,000 of assets that are just in your name individually without any other designation, no beneficiary, not in your trust, not jointly owned, you will still not have to go through probate, because there's what's called an Illinois small estate affidavit, where you could fill out the affidavit. And for cars, DMV has their own. You just give it to them, and they would transfer the title without any need for probate or anything like that. But trying to get a car titled in the name of a trust, they just don't understand it. I've encountered all kinds of problems. The only time I ever do it is if I have like someone who has a big car collection.
Well, that's different if it's a car collection. That's
Right.
more of an investment than a,
And it's usually going to be more than $100,000 too. So
oh, that's true. That's true. You're not gonna title your Nissan that's worth 18 grand in your trust.
No,
That would be
no.
silly. Thank you, Tom, for coming
You're
in. Thanks
welcome.
for the information. This is very useful. I think it's something that one of the many things that there is to keep in mind as we go through. It's like we don't always want to talk about what happens at the end, but this is one of those things to keep in mind, because if you don't make your decisions, the government will make them for you, and it's not in your best interest that they're looking at. It's in their pocket.
That's right. All right. Well, thank you all for attending.
Hey, Tom, one last question. Where are you located physically?
161 North Clark Street in Chicago. So right across from the Thompson Center State of Illinois building,
Okay.
which is now the Google building, I guess. Google bought it, but yeah. So Clark between Randolph and Lake.
Thank you for being part of the second seminar series. We're excited to tell you about the next one once we've got them scheduled. We've got several lined up, and we'll also be having some less business related ones and more soft issues. So keep a lookout for what we're going to do, and thank you again for attending.